the committee.
I thank the gentleman for yielding. Mr. Pickles, is it your testimony or your viewpoint today that Twitter is an interactive computer service pursuant to Section 230, sub C1?
I'm not a lawyer, so I won't want to speak to that, but I understand that under Section 230, we are protected by that, yes.
So if Section 230 covers you, and that section says, no provider or user of interactive computer service shall be treated as the publisher or speaker of any information provided by another, is it your contention that Twitter enjoys a First Amendment right under speech while at the same time enjoying Section 230 rights?
Well, I think we've discussed the way that the First Amendment interacts with our companies. As private companies, we enforce our rules, and our rules prohibit a range of activities.
I'm not asking about your rules. I'm asking about whether or not you believe you have First Amendment rights. You either do or you do not.
I'd like to follow up on that, because as someone who's not a lawyer, I think that's a very important question.
Well, you're the senior public policy
absolutely.
official for Twitter before us, and you will not answer the question whether or not you believe your company enjoys rights under the First Amendment?
Well, I believe we do, but I would like to confirm with colleagues.
So what I want to understand is, if you say, I enjoy rights under the First Amendment, and I'm covered by Section 230, and Section 230 itself says no provider shall be considered the speaker, do you see the tension that that creates?
Yes, but I also see that Congress we've worked with previously to identify why it's important to remove content that is of child sexual abuse, and why it's important.
Okay, well, let's explore some of those extremes then. I know Twitter would never do this, I'll disclaim that, but could Twitter remove someone from their platform because they're gay or because they're a woman?
Well, we would remove someone breaking our rules, and that behavior is not prohibited under our rules.
So it's your contention that Twitter does not have the ability then to remove someone because they're gay or because they're a woman?
As I say, that context is not part of the context of whether they break our rules.
Okay, well, Jared Taylor is a horrible human being who you're currently litigating with, but that litigation seems to, the transcript from it seems to have some tension with what you're telling Congress. The court in that litigation asked the question, does Twitter have the right to take somebody off its platform because it doesn't like the fact that the person is a woman or gay? And the response from the attorney for Twitter was, the First Amendment would give Twitter the right, just like it would give a newspaper the right to choose to not run an op-ed from someone because she happens to be a woman. Would Twitter ever do that? Absolutely not. Not in a million years. Does the First Amendment provide that protection? It absolutely does. So was your lawyer correct in that assessment, or were you correct when you just said that would not be permitted?
Well, I'm not familiar with the facts of that case, and you can appreciate I can't comment on ongoing litigation, but this is absolutely a critical public policy issue, one it's important we debate, because as our companies seek to reassure you in this committee of the way that we take our decisions in a neutral way and not taking into account political beliefs, I think that the fact our rules are public and that we are taking steps to improve the transparency of how we improve the enforcement of those rules are important steps to take.
Right, but it is not in service of transparency if your company sends executives to Congress to say one thing, that you would not have the right to engage in that conduct, and then your lawyers in litigation say precisely the opposite. That serves to frustrate transparency. But my time has expired. The gentleman from Rhode Island, Mr. Cicilline, is recognized for 5 minutes.
Thank you, Mr. Chairman.
Thank you. Thank you for yielding. So I understand your argument and agree with most of it as it relates to the First Amendment, but is your view of Section 230 that it's consistent with First Amendment principles, or do you read Section 230 to say that if you choose to be a public forum, then you surrender those First Amendment rights for the liability protections you get to host content? I yield back for the answer.
Thank you. I am a supporter of Section 230. I yield back.
The gentleman from Ohio, Mr. Jordan, is recognized for 5 minutes.
Thank the chair.
I'll recognize myself for 5 minutes, and I'll begin by associating myself. The way I read that statute now, it's pretty binary. It says that you have to be one or the other. You have to be a Section 230 protected, or you're a speaker with the full complement of your First Amendment rights. I'm cool with that. I would love you guys to make the choice. Community,
But what we know we can do.
And I'll begin by associating myself with some of the comments from Mr. Liu and Mr. Raskin. When they indicate that the government should not foist upon the technology community the over-regulation of the government, I completely agree. My question is, when you avail yourself to the protections of Section 230, do you necessarily surrender some of your rights as a publisher or speaker? The way I read that statute now, it's pretty binary. It says that you have to be one or the other. You have to be a Section 230 protected, or you're a speaker with the full complement of your First Amendment rights. I'm cool with that. I would love you guys to make the choice. I come from the libertarian-leaning segment of my party. I just think it's confusing when you try to have it both ways, when you try to say that, we get these liability protections, but at the same time we have the right to throttle content. We have the right to designate content, and in the most extreme examples, when you have a Twitter attorney saying in court, we would never do this, but we would have the right to ban people based on their gender or their sexual orientation. So I wanted to clear up those comments. But my next question is for you, Ms. Bickert. I've provided to you a screenshot I've taken from content that was published on Facebook from a page that is Milkshakes Against the Republican Party. There are 2 posts. Would you read the first one? And there is one naughty word there that you're welcome to skip over. Will you read it aloud?
Congressman, this is a post, Milkshakes Against the Republican Party. It has a picture, and it says, parents in the waiting area for today's school shooting in Florida. And then it says, you remember the shooting at the Republican baseball game. One of those should happen every week until those NRA, and then there are unpleasant words. And then there's, I'm not sure if this is another post beneath it or not.
Yeah, that's a second post. Will you read that? That has no naughty words.
It says, dear crazed shooters, the GOP has frequent baseball practice. You really want to be remembered. That's how you do it. Signed, Americans tired of our politicians bathing in the blood of the innocent for $a few million from the terrorist organization NRA.
Do these posts violate your terms of service?
Any call for violence violates our terms of service.
So why is Milkshakes Against the Republican Party still a live page on your platform?
I can't speak, I haven't reviewed this page. I can't speak to why any page is up or not up, but we can certainly follow up with it.
So a member of my staff provided these comments to Facebook, and we said, based on our reading of your terms of service, and frankly, based on your testimony today, where you say, we are committed to removing content that encourages real-world harm. Based on that, this would be a facial violation, but I received back what I've provided to you, and the highlighted portion of Facebook's message back to my staff includes, it doesn't go against one of our specific community standards. So do you see the tension between your public testimony today, your terms of service, and then your conduct when you're presented with violent calls to shoot people who are members of my party at baseball practice?
Congressman, there's no place for any calls for violence on Facebook. I will certainly follow up after the hearing and make sure that we're addressing content you bring to our attention. In any
Thank you. Yeah, I mean, I brought it to your attention when I emailed it to you, and then I brought it to your attention when I went to Facebook with Mr. Ratcliffe. We went to California. We went to your corporate headquarters. I showed these posts to your executives, and the response I got from your executives is, well, we removed those specific posts, but we're not going to remove the entire page. So I guess if a page hosts repeated content that threatens violence and that references the shooting of Republicans at a baseball game, why would you not remove the page?
Thank you, Congressman. Okay, so these posts were removed, but the page has not been removed. Is that
correct?
Correct. Okay. So we remove pages or groups or profiles when there is a certain threshold of violations that has been met. So, and this depends. If somebody, for instance, posts an image of child sexual abuse imagery, their account will come down right away. But there are different thresholds depending on different violations. So I can follow up with you on that.
How many times does a page have to encourage violence against Republican members of Congress at baseball practice before you will ban the page?
Congressman, I'm happy to look into this and look at the page specifically and then come back to you with an answer.
You agree this is a mistake, right?
The post should not be on Facebook. I have to look at a specific page with my team before we can.
Do you think that this page should be hosted on Facebook with these multiple calls for violence against people in my party?
Congressman, I personally have not seen the page on Facebook, but I will look into it with my team.
You've seen these posts, though, right?
With the chairman, for a sympathetic question. I'm agreeing with the chairman about this, and I think we arrived at the exact same place when we were talking about at what threshold does InfoWars have their page taken down after they repeatedly deny the historical reality of massacres of children in public schools? And so when you follow up with it, and obviously you want to look into the specifics of the case, I would love it if you would follow up also about Alex Jones and InfoWars. If certain content you're saying has been taken down when they are taunting the students from Parkland, but at what point does the whole page get taken down? And I agree certainly that that these posts should be taken down that the chairman's talking about. I yield back.
I thank the gentleman and would concur with his sentiments. My time has expired. And seeing no further business before the committee, this concludes today's hearing. Thank you to the distinguished witnesses for attending. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. The hearing is adjourned.